My name is Todd Dime. I'm a Michigan bankruptcy attorney. This is a short video to explain to you the basic concepts in a Chapter 13 bankruptcy. Basically, there are two types of bankruptcies. There's what we call Chapter 7 and what we call Chapter 13. Chapter 7 is the most common type of bankruptcy. It's a total discharge of all of your debt, and it's a relatively short bankruptcy, about 3 months start to finish. There's a separate video I have you can see, and you can watch that and learn about that. This video is about Chapter 13. Chapter 13 bankruptcy is basically a repayment plan where you repay all or part of your debt over a period of time, anywhere from 36 to 60 months. Chapter 13 is used a lot if you have really high income under certain guidelines, if you have a lot of excess assets under certain guidelines, or if you're trying to stop or save a home from a foreclosure. And there are some other various rules to use Chapter 13 that make sense. For example, if you're trying to avoid a terrible divorce property settlement agreement, and if you're trying to modify claims or the amounts owed on certain types of personal property, certain types of car loans or commercial property that may be used in a small business. A couple things about Chapter 13. One, you can pick and choose what debt you want to keep. You can keep some of your debt and actually modify your claims. So if you want to keep your home, you can normally keep a mortgage in a Chapter 13. And in some situations, if your home is undervalued or underwater, you can actually remove a second, third, or fourth mortgage right off of the home. Literally strip off the value of that mortgage from your home. And that's one reason to use a Chapter 13 is when you're underwater in a house. You also can keep car loans, and again, depending on how old the car loan is, for example, if it's over 910 days old, you can actually reduce the amount owed on the car loan and the interest rate to something reasonable. There's a lot of flexibility for you as a debtor in a Chapter 13 to modify the rights of your creditors. So it's a very powerful type of bankruptcy. The other thing that's important in Chapter 13 or any type of bankruptcy is the concept of exemptions. When you file bankruptcy, you're allowed to own property, you just can't own too much property. So for example, there are two basic sets of rules for keeping property in a bankruptcy. There are the state rules and there's the federal rules. It depends what state you live in and what the rules are in that state. Here in Michigan, we primarily use the federal rules. Under the federal rules, for example, a married couple can have up to $40,000 of equity, roughly, in a home, and it won't be touched in a bankruptcy. A married couple will have roughly $20,000 of household goods, couches, chairs, clothes, refrigerators, whatever. A married couple can have roughly $7,000 of equity in a couple of automobiles, roughly $3,000 worth of tools used in your trade or business. You can have an unlimited amount, even millions of dollars, if you're so fortunate, in a 401k, IRA, or other ERISA, or federally approved retirement type program. In fact, if you didn't own a home, you could actually take $20,000 of this and apply it to any property. You could actually file a bankruptcy with $20,000 cash laying on your kitchen table, and no one could touch it because you're allowed to have that much. The idea is at the end of the process, they want you to have some type of assets to go forward with to get your fresh start. The way Chapter 13 works is relatively straightforward. Prior to filing any bankruptcy, 7 or 13, you have to take something called a credit counseling course. And it's required by law. It takes about 30 minutes with the company that we use, and basically it's a budget exercise where you answer questions and analyze your family budget. Assuming you've done that, what your bankruptcy attorney typically does is comes up with a Chapter 13 plan and fills out what's called a petition and schedules that lists all of your financial information, all your assets, liabilities, income, and expenses. And once you review and approve and sign all those documents, they're filed with the court. When we file those, the judge immediately issues an order, a federal court order, and sends out that order directly to all of your creditors, ordering them to leave you alone. That order suspends any garnishments, judgments, stops any foreclosures. Your creditor is not allowed to call you, send you letters, harass you in any way whatsoever. It's immediate relief to get the creditors off your back. Now, the way a Chapter 13 works, the whole concept is some type of plan of reorganization. And there are literally hundreds of variations of how this would work, but I'm going to give you a very simple explanation as to the fundamental concept behind the plan. The idea in the plan is that your family has a certain amount of income coming in, and let's just say, for the sake of argument, is $3,000 a month after paying your taxes. And your family has a certain amount of expenses that it has to live. Food, utilities, dog food, haircuts, prom dresses, whatever. So we figure out what your expenses are that you need to keep your family that are reasonable and necessary. And depending on what part of the country you're in and who your bankruptcy judge is and who your trustee is, these can vary. But let's just say that it's $2,000 a month. And let's say that includes everything, and let's say that includes a car payment just for fun. But the one thing it doesn't include is we're going to say it doesn't include your house payment because you got behind on your mortgage. And let's say that your regular house payment is $700 a month. And let's say, just for the sake of argument, that you're $3,600 in arrears on your house payment. So you're in the hole $3,600. We have to catch that up. That's the purpose of the bankruptcy in Chapter 13 many times. So if you have a 36-month plan and you owe $3,600, it's going to take about $100 a month to catch that up. So about $800 a month is going to go to the mortgage company. So we got $3,000 coming in, we got $2,000 going out for everything but the house payment, which leaves us about $1,000. And the purpose of this particular bankruptcy is to save your home. So we know that our regular payment is $700. We need $100 to catch up, which leaves us $800. So we have about $200 left over. Okay, so this is what I'm going to call the extra. And here's the idea: each month, when you file your bankruptcy case, you're going to make that payment to what's called a trustee. And a trustee is a lawyer. It's not a judge. It's just a lawyer appointed by the local court, the bankruptcy court, to administer these payments. So you're going to send $1,000 a month to the trustee. The trustee is going to send $700 to the mortgage company to make your regular mortgage payment for you. And the trustee is going to send another $100 a month to the mortgage company to catch up what you got in the hole on. And then let's just say that you ran up $30,000 in credit card debt. Let's say it's $33,000. The trustee is going to take this extra $200 a month and he's going to build it up in a pot. So you're going to make that payment for 36 months, the whole $1,000, and the extra money he's going to put in the pot. So over 36 months you're going to build up $7,200. Okay? Well, you owe $33,000 to Capital One, Discover, and all them people. What happens is they come in and they fight over the nickels. They're all going to get about 20 cents on the dollar, 22 cents on the dollar. And at the end of the plan, because you paid what you could afford, the rest of the balance that's owed to your unsecured creditors is going to be discharged. In this particular case, you're dumping about 80 cents on the dollar to your unsecured creditors. They're just not going to get paid. They got the nickels, and that's all they get. And at the end of the day, because you paid what you could afford, you're going to receive what's called an order of discharge. And that's a federal court order that discharges you from all of your debt that was not paid in the plan. So that order of discharge is the fresh start you're actually looking for. And in that process, you fixed your mortgage, you saved your home, and everything's current when you file it. So that's how a plan works. The extra money catches up what you need to catch up, gives your unsecured creditors the few nickels that they're entitled to, and at the end of the day, because you did sacrifice and pay something, you receive an order of discharge. Now just get back to the process. Once we file this plan, about a month after we file, we have to go meet with the trustee, who is the lawyer appointed to administer this money. And those meetings normally are pretty short. These are also known as the meeting of creditors or the 341 meeting. These meetings will run anywhere from 3 to 10 minutes. And then normally after the trustee meeting, the trustee or some of your creditors will object to your plan. They don't think they're getting enough money, they don't like the language your lawyer used in the plan. And generally over the next month after the trustee meeting, your lawyer and the trustee and some of the creditors work out these objections, and sometimes the judge actually has to make a decision as to who gets paid what. But eventually the plan gets confirmed. And once it's confirmed, you're going to make your plan payment for whatever you agreed to, in this case 36 months, and at the end of the day, because you did what you said you do, the court will enter an order of discharge. One other thing, after we file, there is one other class you got to take called a financial management course. Everybody has to take that, and basically the company I use, it's a movie, it's about an hour and a half long, and it's an educational seminar on how to manage your money and your finances. But that's the idea in Chapter 13. You pay something back, you can fix bad loans like on your home or your car, and at the end of the day, you get an order of discharge. There's a few other things I want you to know. If you just watch this video to the end, then obviously you have concerns. Most bankruptcy lawyers will do a bankruptcy consultation at no charge. Do yourself a favor. Don't spend all of your assets, your money, your 401k, sell your quads, your snowmobiles, trying to keep a sinking ship afloat. Call a local bankruptcy attorney, someone who is competent and experienced. Do a free consultation. Learn what your options are. The other thing is, do not call a debt settlement company. They're a pack of thieves, liars, racketeers. It's the biggest fraud going in the United States today. If you don't believe me, go to the Federal Trade Commission website and read up on the latest study of these guys and how they steal money from people like you who are struggling and trying to get a fresh start. Use the federal bankruptcy process, federal bankruptcy judge, a competent attorney. Get yourself a fresh start. If nothing else, do yourself a favor. Go get a free consultation. I'm Todd Nye. I'm a Michigan bankruptcy attorney. You can go to my website, nylaw.org. My phone number is on there. I'll be happy to meet with you at no charge and explain your federal rights. Thank you.